Mr. Ifo was in a statement is reacting to some of the issues that have been raised and says that the certified true copy of the Friday's Supreme Court judgment on the Labour Party's leadership crisis at the parallel National Executive Committee held by the LP presidential candidate Peter Obi and Governor Alex Otti in Abuja is nothing to rejoice about. When the Labour Party spokesperson mocked the gathering, saying there was nowhere in the CTC that a court mentioned that Abure must step aside. Let's get some clarity on this one. I'm being joined by Mr. Kendi Edwin, who is the legal advisor of the Labour Party. I don't know whether by the that the judgment of the Supreme Court is over. You'll be speaking with us on. Are you a former or you are still substantive legal advisor of the Labour Party?
I'm substantive. I'm in office. I'm functioning. And my position is secure.
Yeah, and I'd like to put this caveat out. That as a lawyer, you've sworn to the Supreme Court of the Federal Republic of Nigeria, and you are also put yourself forward to obey the judgment of court and they uphold the Constitution of the Federal Republic. These, to paraphrase, these are some of the oaths that every lawyer who is bowed before the Supreme Court and being enrolled to practice in Nigeria, these are some of the words that you plead as oath. And I'm understanding tonight that you are going to speak in truth to the judgment of the Supreme Court. In your own assessment and interpretation as a lawyer, if laymen interpret the judgment wrongly, you can excuse them. But as a professional and a lawyer called to the Supreme Court and the bar of the Nigerian bar, what is your interpretation of that page 47?
Now, what the court has said is to emphasize the supremacy of the party. The supremacy of Labour Party over its internal affairs. And we are happy about that judgment. The Labour Party is happy that the court has advised everyone to obey what the party has done. And when you are talking about the party...
that the party has done?
Yes.
What is it?
That the party is running, the party has taken decisions which is binding on all members. And when you are talking about the party, a party has governing bodies. The governing bodies are the organs of the party, from the National Convention to the National Executive Committee to the National Working Committee, the State Executive Council, the State Working Committee, down to the Local Government Executive Committee, the World Executive Committee, and the World Congress. What you have to realize is that the constitution of the party has actually stipulated how these bodies, how the membership of these bodies, how meetings of these bodies can be convened, and how decisions can be reached by all these bodies. They are organs of the party. And today, there is no doubt about it that these organs are led by individuals who have the authority to convene the meetings of all these organs. Let me tell you, this so-called caretaker committee, the foundation is faulty. There is nothing there. There is nothing that can come out of it. It's like when you talk about maybe somebody that has a K leg or a W leg, as they call it, and that person is carrying a load on his head. And people are saying, oh, your load is wobbly. You say, no, it is not from the head that you look at. Look down, look up from the leg. If the foundation is faulty, there's nothing that you can put on it. You can't put something.
But at the time the caretaker committee was set up in Umar here, there wasn't anything like Julius Abure as a national chairman, because at the time, he was in abeyance as far as the law is concerned.
There is nothing like being in abeyance. Once a party has taken a decision, no court has the power, and if no court has the power to set aside the decision of the party, INEC can also not set aside the decision of the party.
So let's look at what the Supreme Court judgment says.
Okay.
So in that case, you agree with me, as far as the facts are concerned, there are two appellants.
You're right.
Senator Leonard Usman and Honorable Umokocha. And on the other side, the respondents at the Labour Party, which you, Mr. Abure, and they all came under, and INEC. Now, let's go to page 47, the summary of the judgment of the Apex Court. And I'd like to read to you, Mr. Edun, some parts of what the judgment has revealed. In summary, the Supreme Court says, both the trial court and the court below had no jurisdiction to entertain the suit of these first respondent, which is the Labour Party, where you were defending, to entertain the suit of the first, which may relief, as the both rightly observed, was inserted as relief number 5, as though it was an appendage. There's a fault that the Supreme Court has given based on some of the relief that you sought. Consequent upon the foregoing, the decisions of the both trial court and the court below, recognizing Barrister Julius Abure as the national chairman of the first respondent, are hereby set aside and suit. I mean, what does that mean? If the Supreme Court said the judgment of both the trial courts, the Court of Appeal and the High Court has been set aside, the Court of Appeal says what?
No, let me explain to you what the court meant by that. What the Supreme Court meant.
Okay, so just a moment. Okay. Let's understand, because if these are the judgments that has been set aside, let's take the Court of Appeal judgment, because the trial, if you go too far, the High Court judgment. Let's say the Court of Appeal. What was the ruling about Julius Abure at the Appeal Court? Because the court felt that the Supreme Court said that no court should have entertained any matter by which anybody will be declared as national chairman. I'm saying that, so just a moment, don't let us model things. The Court of Appeal, did it say that Julius Abure should be the national chairman or not? And the Supreme Court said that. Just a moment, Mr. Edun, don't let us model things. Did the Court of Appeal say Julius Abure is the substantive and authentic national chairman or not? Remember, is that what the Court of Appeal said? Remember that court said that he has no jurisdiction to even entertain leadership issue in the political party. Don't let us now went ahead to say that. Don't let us come to the Supreme Court. No, I'm talking about the Court of Appeal. The Court of Appeal, yes. The Court of Appeal said clearly that he has no jurisdiction to pronounce anybody as national chairman of a political party. He now went ahead to say, but there is a judgment of this court that already settled that matter. What the Supreme Court said is that that Court of Appeal shouldn't have made reference to that judgment. He should have let that judgment as it is. Not that that judgment was wrong. Not that that judgment that declared that by which Abure was admitted by all the parties as national chairman. The Supreme Court did not say that judgment was wrong. The Supreme Court only said that because in this case, the court has no jurisdiction to delve into the leadership matter. And the court already said that it did not have that jurisdiction. That the court shouldn't have made reference, shouldn't have made any finding based on an earlier decision. Those are the inferences. Those are the inferences. The court said that. The rest, which is the court, I mean, the Supreme Court is standing on right here, is that Mr. Abure, that has been recognized by the judgment of the Court of Appeal, that judgment has been set aside. Yes. Anything that is contained in that judgment, as far as the law of Nigeria is concerned, is nullity. The Supreme Court said that the suit in the trial court, and also that appeal, the Supreme Court struck out. So, the only thing that the Supreme Court set aside was that reference to an earlier judgment, in which the court said that for clarity, that the leadership of the Labour Party is as in the judgment of this court that was decided on 13th November 2024, in which one Barrister Julius Abure was admitted as the national chairman. The Supreme Court said that that court shouldn't have made that reference. So no matter what the inference... Not that earlier judgment was wrong. Yeah, but the fact remains that it has been struck out. Yes, that appeal was the only reason why... Just a moment. The only reason why Mr. Abure calls himself a national chairman is because the appeal court says so. No. Because Barrister Julius Abure was elected at the National Convention of the party. But it was disputed, isn't it? Anybody can dispute anything. The fact remains that you went to court to settle the dispute, isn't it? No. Why did you go to court? We went to court and sued Abure. Let me tell you the genesis of this matter. We went to court to sue INEC. It was when INEC refused to release the code for the upload of names of agents for the Ondo governorship. That's the origin of this matter.
It was not, in fact, Nenadi and the caretaker committee were not part of the suit originally because we had no dispute.
You were seeking clarity
now,
as to the powers of Abure-led NWC to be able to conduct the primaries and stand as...
Primaries was already conducted. A candidate has emerged.
There were parallel candidates. Don't forget.
No, that was not why we went to court. INEC already accepted the name of that candidate, and the name of candidate already uploaded as the candidate of the party for the Ondo governorship election. The reason we went to court was, now we needed to upload the name of our agents for that election, and we needed a code. The code needed to be given to the party by which we submit the name of agents. INEC did not release the code in time, and there was a training for those agents, and we needed to submit the names of our agents for INEC to train them, and INEC did not do that in time. So we now said that no, we are entitled to all these. These are privileges that should be afforded to all registered political parties who have nominated candidates and whose candidates have been accepted by INEC. So that was the reason for going to court. Now Nenadi now came, and the Nenadi-led caretaker committee now filed a joinder that they want to join in the suit. We filed a counter against it, but the court decided in this wisdom to join them to the suit. That was the thing. So when they went to after the court decided and said, well, INEC was supposed to have given this code to us, and INEC supposed to release this code to Abure. Now, that was the decision of the court. But the Nenadi-led caretaker committee went to the Court of Appeal and said that no, that court should not have made that decision. The Court of Appeal said from the beginning of the judgment that that appeal was odious and of no moment, because this matter was about the Ondo governorship election, which
not about the leadership of the party.
No, let me what the court said. That this case was about the Ondo governorship election, which had held and was passed, and because of that, that appeal was odious, of no moment, and was merely academic. But after saying that, and that was liable to be struck out, that was liable to be dismissed. Now, when the court said that he should have dismissed that matter, but you now went ahead that, well, this may go on appeal to the Supreme Court. So let me now review all the issues raised. So he went ahead to review. After reviewing all the issues, the court now concluded by saying, well, I've reviewed all these issues, not that I had jurisdiction, but because this matter may go on appeal to the Supreme Court, so that the Supreme Court will have some materials to work on. He now said that for clarity, that the decision about the legislature of this body had already been taken in an earlier decision of this court. He now made reference to that decision that same justice wrote. And he now said, I already wrote a judgment about the legislature of the party. And this is what the judgment said, that in that case, it was admitted by all the parties that Mr. Julius Abure is the national. And he now said that judgment, and he said that judgment is still subsisting.
I wanted you to land. So if there are issues as to who has a rightful entrance or ownership or possession of this house, and we go to court to say, I need to get the key, and Mr. Edu say, no, you cannot get it, and the Court of Appeal say, Sheung, you have the rightful ownership of the key, take the key. Isn't the court telling me that I am the rightful occupant or owner of that house? Is that not what the court has said?
Which court?
I'm trying to put a clarity so that our viewers can understand, because some of these legal issues could be confusing, and that's why we are here to break it down. And I'm saying that substantially, what the Court of Appeal said is that Julius Abure is recognized as the national chairman because the Supreme Court has decided. Now that he said, the Supreme Court said that is doesn't have any basis and been struck out.
Yes,
now
the Supreme Court said that even though you already decided that matter, but you shouldn't have imported that reference.
Let us not go far.
You don't have...
Let us just stay on the fact that as far as the Supreme Court is concerned, the decision of the both trial and the court below recognizing Barrister Julius Abure as a national chairman of the first respondent, which is the Labour Party, are hereby set aside and is hereby struck out for want of jurisdiction.
Yes.
In the same vein, the first respondent, the Labour Party's cross appeal, being an offshoot of the same judgment of the court below, is hereby dismissed.
Let me tell you why.
Just for a moment, sir. Before I am done, this is a judgment and this is not an obiter.
Yes.
He said, may I admonish political parties and their members to endeavor to always allow their constitution, rules, regulations, and guidelines to guide them in choosing their officer as well as candidate. That way, incessant internal rift, which always find their way to court, will be reduced. If the constitution of the political party has prescribed duration for tenure of office on an officer, such officer should be humble enough to live at the expiration of the tenure. Who do you think the Supreme Court is talking about here?
Did not mention.
Who do you think is the Supreme Court is?
The advice is for political parties generally. But let me tell you, in this instance, that does not apply to the Labour Party. The Supreme Court has said that political parties should follow their constitution. And by the constitution of the Labour Party, according to what the Supreme Court said, yes, there was a tenure created in 2019. That tenure was supposed to expire in 2023. The neck of the party made a decision for the extension of that tenure. And that tenure was now supposed to expire on the 9th June 2024. But before that, a convention held. A convention of the party
that was not totally agreed upon by everyone.
Who?
How do you?
All the organs of the party are in support of that convention.
Just a moment, Mr. Edun.
To set the
what
agenda.
Is the structure of holding congresses of the party? Do you start from the top or you start from the bottom?
By the constitution of Labour Party. The ward, the local government, and the state, they have a 3-year tenure. Now, why national officers have 4-year tenure? Their tenure do not end at the same time. So by the time the tenure of the national officers are ending, the tenure of the states, the local government, the wards are still subsisting. So they don't hold it at the same time. There is no law, there is no rule that says
so
that.
So you are saying that all those structures still have their tenure intact?
By the time that convention held,
all right, just a moment. Let me allow you to listen to Governor Alex Otti.
Okay.
What he said in Transcourt today. Take a listen to him.
I had sat with Mr. Abure last year, and I asked him, I said, what do you really want? And he said he didn't want anything. I said, okay, I can speak to my leaders, and you can become a BOT chairman. I offered that with their approval. Or if you want to still lead this party, let's go through the process. Go and purchase a form when the process starts, and if you win, you return as chairman. But I also gave him some pieces of advice. I said, if I were you, I wouldn't want to lead people who wouldn't want me to lead them. So if you come into this kind of room, and I present myself and I said, I want to be your chairman, and you say you don't want me to be, there is no way I can impose myself. So we are still extending the olive branch to him and those in the former National Working Committee to sheath their sword. There's no need fighting. They will just be delaying the doomsday.
With due respect to the governor, it is not the province of the governor to distribute positions in the party. There are organs of the party. For example, the National Executive Committee is supposed to set agenda for the National Convention, to set dates and agenda, which the National Executive Council sets.
If they're asking you and your colleagues and Mr. Abure to step aside, in the interest of the progress of the party, would you be stepping aside?
As far as I'm concerned, positions in the party are not so important to me. But the due process must be followed. Somebody cannot just stand up because he's governor.
So because they are seeing you and Mr. Julius Abure are sit tight and that you are being sponsored by...
I've only been in office for 1 year.
They say you are being sponsored by external forces.
That is not correct. If some people think that they can crush you because they are bigger, they are richer and everything, and they have not been able to crush you, they wonder where is your strength coming from. So it is natural that they will make speculations as to anybody sponsoring you. But that is not correct.
We wish you and your party the very best. Thank you so much indeed for your time.